We've been reviewing the book from Paul Hajek from Clutton Cox. Don't even think about buying or selling your home until you've read this book. It's a 5-star rated Amazon book, and we've been going through the chapters, just really explaining some more information about these chapters. So let's just say your conveyancing solicitor has identified a problem on the house you are buying. Let's say there's a restrictive covenant relating to the property. Now, your conveyancing solicitor might need further deeds of rectification or variation, or statutory declaration from a knowing person could be obtained, or when all else fails, an application to a court or tribunal for a ruling on status of the defect. Now, in the real world, when your sale or purchase is linked to a series or chain of transactions, the pressures are such that it takes time to investigate, and alternative remedy is limited or often too costly. So what happens next? Well, in a busy modern conveyancing law firm, defective title indemnity insurance has been the line of least resistance in solving such problems. That's right, title indemnity insurance. Your conveyancing solicitor will either call for or be called upon to provide an indemnity policy to cover the defect. When you're buying a property with a mortgage, your lender may insist upon a policy before agreeing to release the mortgage advance. Now, solicitors have an exemption under the Final Services and Markets Act of 2000, where they are allowed to arrange indemnity policies where the activity is incidental to a conveyancing transaction. Now, conveyancing solicitors normally arrange the indemnity policy themselves under a self-certification scheme for very straightforward issues. For more complex issues, the solicitor would write a report setting out the facts and sending it to special underwriters. The premium is a single premium and not a recurring yearly premium, but it's typically between £250 and £500. Now, is a defective title indemnity policy all it's cracked up to be? It's likely to be a sticking plaster in the majority of cases, but it may suffice. There are also a few issues you should be made aware of. Now, the policy may only run for a certain period of time. The policy is confidential and may only be disclosed to prospective purchasers, their mortgagees and their respective legal representatives. This is to avoid the insurer's eyes and people coming out of the woodwork and making claims. Now, the policy may be avoided if there's a change of the use of the property, e.g. from residential to business use, so it could be voided there. And you will not be covered for the full amount you paid for the property, but merely the adverse difference in the market value of the property. Now, indemnity policies may not be a perfect solution, nor even an adequate solution, just currently the only solution. At a conference of about 350 conveyancing solicitors, Paul Hajek was there, and the audience was asked had they known a situation where defective title indemnity policy had actually been invoked, and not one single hand went up. Now, complicated, but the best thing you can do about this type of defective title indemnity policy and problems with the conveyancing process is simply talk to your conveyancing solicitor. Paul Hajek at Clutton Cox is an expert in this area. Download his book from his website and then get in touch if you have any problems with your conveyancing process.